Well, my first impression is that the tribe's argument is firmly based in standing law. And the state's argument is based on a ridiculous, newly crafted opinion. And that to suggest that the tribes historically were never on the water, they only had 1 foot in the water and 1 foot on the land when they engaged in sustenance rights, is absurd. And I don't know how it passes a straight face test. I can't see that it can pass the straight face test.
Can you explain that a little bit more, what the state was saying, particularly about what they believed tribal sustenance fishing rights to be? They said that they would not be infringing, or they were promising not to infringe upon sustenance fishing rights, and believed, again, as you said, that sustenance fishing rights is standing with 1 foot on the islands.
Right. Well, essentially, the state's position is that the tribes did not retain any rights to be on the water. So if they were going to engage in sustenance or subsistence fishing, that they were going to have to remain on the land of the islands that are in the river as part of the reservation, and that no portion of the waterway is contained within the reservation that's been carved out for the tribes in the agreement. Even though all of the agreements specifically state that the tribe still has sustenance and subsistence fishing rights, the state's position is that there's no water included, and you can't have islands without water, you can't fish without water. And I think that the judge's question really hits home when he asked the state, now, are you suggesting that the fish that the tribe is supposed to be taking in regard to their subsistence rights are going to be found on the land? It just shows the absurdity of the state's argument. And also the judge stating, are you saying that the tribes have never been on the water? We are a riverine people. We've always been on the water. You look at all the historical pictures of the Penobscots, and they're in canoes on the water. And so I think that when you look at the meat of the state's argument, that there's no substance. There's absolutely no substance to it. And I would be shocked and frankly quite suspicious if the court rules in the state's favor.
Do you want to comment on the interveners' involvement in this case? The judge seemed to be really questioning whether they had any argument to be there.
Well, I don't think that the interveners have any argument to be there, because none of the issues that are before the court. The judge can only decide on the issues that are actually before the court. None of the issues that are before the court are issues that have been brought up by the interveners.
Which are, if you could just quickly say?
Essentially that the tribe is going to regulate discharge of non-tribal members on non-tribal lands. It's not at all at issue. The tribe doesn't believe that it will assert those rights. The tribe has never assumed that they had those rights to regulate non-tribal members on non-tribal lands. There is an agreement right now between the state and the EPA to regulate those discharges, and that the state will regulate those discharges. And you can't bring into a lawsuit an issue that's not before the court and expect the court to rule on it. You can't say, someday this might happen. The court is not going to rule on a speculative issue, and everything that the interveners brought forward today was speculative. There is nothing that's grounded in any type of merit whatsoever. And so I don't see how the interveners come into play at all. And I think that it's an incredible waste of money to whoever the third party is that's paying for the interveners case, for them to have been involved in this case at all. And, we saw today that the position of the interveners is trying to assert that the tribes are going to somehow come forward and start regulating their activities, is part of the basic problem with this case from the beginning, which is that it's been grossly misled. The facts in this case have been grossly misstated by the interveners. And there's also quite a bit of question about whether or not the interveners have even been properly joined to this case, because there's no town resolutions that anybody can show us. There are no third-party disclosures about third-party paying for this case. And so when you look at those issues, the interveners in this case really are a distraction. And hopefully the judge sees them as that.
And just quickly, I know because we started believing that those watching or listening had a sense of what this case was. If you can just quickly clarify that for the Penobscot Nation, this case is about territorial taking and about retaining sustenance fishing rights. If you just want to.
Right. And I think that, the state claims that that the tribe is bringing forward a case that has no merit. Because there has been no claim against their sustenance rights or their territorial rights. However, the Attorney General issued a memorandum stating that the tribes did not have these rights. That is a direct attack on the rights of the tribe. And so the tribe is not trying to come forward and assert any control over the waterways. They're not trying to come forward and change the way that others are relating to the water. The tribe specifically is retaining the cultural and traditional relationship that we have always had with this waterway. It's the Penobscot River. We're the Penobscot people who live in the Penobscot Nation. It's absurd to think that there's any separation between the three.
Thank you very much.
You're welcome.
I'm Maria Gerard from Penobscot Nation.
So, comments, reflections, hopes, impressions about today, the court proceedings today, and the case where it stands.
Well, I'm glad the oral arguments are behind us. I feel really hopeful. I think our attorneys did a really good job. And I also think that the state of Maine and the attorney for the interveners really put out some absurd notions. And I'm feeling hopeful. I was overwhelmed at first when we came in, just kind of hoping to get this behind us. And when the arguments were done and I stood up and saw the crowd of people there, it was really overwhelming, the support that we have. So I'm staying hopeful. I really am.
And we'll get back to the case in a minute, but you talk about the crowd of people. You've been really active in building a movement with allies and with the tribe to really stand up for this case. Do you want to talk a little bit about that allies movement and the movement to educate people about this and to stand up?
Sure. Well, for about the past decade, I've done a good amount of educational outreach throughout the state on tribal history, and culture, and it was always my impression that the majority of the people in the state of Maine really had no idea of what sort of relations went on between the tribe and the state. In August of 2012, the state issued their memo, which caused this whole case to have to take place, and that was their memo asserting that our reservation, which contains over 200 islands in the Penobscot River, contained absolutely no portion of the water. Now that was a completely ludicrous assertion, and a couple months after that I did a term on Penobscot Tribal Council, and so I learned a lot of the ins and outs of this case and how it was playing out. And it was a real hardship actually for me to be on council, because at that time we were considered party to the case as council members, and so I was really discouraged from speaking publicly about the case. And so as soon as my term was up, I set out to sort of sound the alarm, and it was always my opinion that people were doing the best that they could based on the knowledge that they had, and that they just didn't have the knowledge. But once they realize the situation and they learn the complex and deep history behind it, they don't want to do that anymore. They don't want to be that way anymore. And so we see that overwhelmingly in the support that the tribes had at events, rallies here today at the hearing.
Because we heard different interpretations, or some would say distortions of what this case is about, but I know that for the tribe and for the work that you've been doing, you're clear this is about a territorial taking.
Yes, we view this assertion by the state government as an attempted territorial taking. We once had, 2/3 of the state of Maine as our Aboriginal territory, and now we're down to, over 100,000 acres. And so I really facetiously say, you've taken all this land all these years, and now you want to take every drop of the water too? So it makes completely no sense. We are a riverine culture. So much about our culture, about our language, and our ways of being the river is central. You can't separate that. And it just makes no sense to the tribal understanding of things.
There was a lot of talk about how one defines sustenance fishing, and the state, as we spoke with other people, are talking about sustenance fishing, that they would consider that being the tribe being able to stand on land with 1 foot on land.
That was just ridiculous. It's laughable. And the example that the intervener gave about the tribe in our own experts' testimony, he mentioned fishing off the islands at Old Town Falls. Well, if you have an understanding of our geography, you would know that Old Town Falls is a drop of about 10 to 12 feet. It's where the present day Old Town Dam is. You can't fish from a boat in the Old Town Falls, but that doesn't mean that we didn't fish from a boat in all the rest of our territory, to limit the sustenance fishing from the islands. And then to, how did they say that? That we were pretending that was demeaning. That statement is demeaning. Like we just concocted this for nothing because we don't have anything else to do but be in court. It seems a really basic right to defend. And if you have an understanding of the historical context of how the reservation was formed, it is clear as day that we still retain that river. We wouldn't give it up for anything. So it seems to me from today and how they kept introducing all these issues that really weren't in question with this case, it seems to me that they're trying to throw everything in but the kitchen sink so that they can just put the nail in the coffin for the Penobscot people.
And one of those arguments being the intervener's argument that this case has to do or would somehow affect water quality discharge permitting.
Right, that's not an argument at all. That's already been decided. According to the Maine Indian Land Claims, the state of Maine does have the power to regulate the discharge of the polluters in the river. It's already been determined. So for them to say that the tribe is somehow trying to control that is, again, putting things into this case that is not even what it's about. This is a territorial protection. This is an action by the tribe to protect what little we have left and to ensure sustenance fishing for future generations. The whole reservation, when it was first recognized in 1775 as part of the congressional resolves, it was very explicit that the reservation was for sustenance hunting and fishing territory so that the tribe could live the way they had lived traditionally for thousands of years before state even became a state of Maine. And so this was our Chief Joseph Orono who ensured that those protections would stay in place, and it was supposed to be in perpetuity, but apparently the state of Maine doesn't know the definition of perpetuity.
And you're a historian of the Maine Indian Claims Settlement Act, and again, this has been an example where the state says that the tribes gave up the water or didn't reserve those rights under the Maine Indian Claims Settlement Act. And as we've said before, the Maine Indian Tribal State Commission, which was created under the Act to resolve or at least comment on particular disagreements, is basically ignored. Their recommendations ignored. But you want to talk a little bit about this, how the state has continually used the Maine Indian the Maine Indian Settlement Act as part of their argument, and in this case, that the water is not part of the reservation.
Well, I do know the context around which the Maine Indian Claims Settlement Act was crafted. It was an incredibly hostile time, full of racial hostilities, and I don't feel that the tribe really got a fair shake. There was a lot of things going on in the United States at that time. There was a real uprising with Indian tribes at that time, and the Penobscot and Passamaquoddy land claims was just one of many land claims that were happening all over the United States at that time. So in my opinion, the Maine Indian Claims Settlement Act has been repeatedly misused. It's been used as a tool to continue to oppress the tribes, and it was interesting that Jerry Reed, the attorney for the state, implied that the tribe was trying to go back and fill in those things that they left out of the land claims, and we believe that that's what they're trying to do, that they're trying to throw everything in that they forgot. It's very clear that they recognized our reservation as including the water. There's been an Attorney General's opinion in 1988 that said our reservation included the waters. And very recently, following the settlement of the 1980 land claims, an attorney came to the tribe and was trying to get them to amend the understanding of the scope of the reservation at that time, and the tribe didn't go along with it. They were trying to get the tribe to say that the branches weren't included in the reservation because they weren't explicitly given up during the land claims, and the tribe refused to acknowledge that. And they said, no, the river's ours. It has been historically, and we remain that the river is ours. And so I always love to use my favorite quote from history. In the early 1800s, in a historical petition, it said, the Penobscots believed that the God of nature gave them their fisheries and that no man alive has the right to take that from them. That's our story, and we're sticking to it.
Anything else you want to add going forward from this day? There'll be some time before we get a judgment, but talk about the social movement from here.
Yeah, I think people really want to be part of a winning team, and I think that people are believing that we are the winning team. Our ancient prophecies and our cultural traditions have talked about a period of time that we're in right now. The prophecies had talked about a period of time when the rivers would run bitter from disrespect and the sea would turn black and the fish would become too poisoned to eat. And so it seems to me we've reached that time now. And then it predicted a period of great hope when new people would come together and realize their common grounds or their common waters, and that they would stand united together. And our traditional teachings also tell us that this period of great hope, or the great healing as it's been called, is going to start in the east. So here we are.
And then finally, the nuts and bolts question for people who want to know how to get involved, particular actions that you're asking people to take.
I'm really at a loss of what to suggest because I don't know. Pray like hell. I really don't know. I've said in the past to write to the legislators, to write to the Attorney General's office. I don't know what good it will do, but I am certain that this case is not representative of the people of the state of Maine and their wants and desires. Despite what the state of Maine says, they are not acting on behalf of the people of the state of Maine. It looks like they're operating on behalf of the polluters and the industries.
Anything else you want to add?
No.
Thank you very much.
Thank you.
My name is Kathy. I'm from Penobscot Nation, and I came here because I wanted to listen to both sides of the argument. I leave here with a lot of hope, and in my heart I feel like they will listen to us. My ancestors told me so. I have a processor as well, so I really cannot engage in any kind of reactionary thing towards them because I'm not, like I said, need to process. I just want to let people know that and thank everybody out there for being supportive of our people. It means so much to me. The river to me is like it flows, it's water that goes through me as well. I'm part of the river, I'm part of the land, and when they try to put ownership on that, they're trying to put ownership on me as well. I like to see that river flow freely as the water flows freely through me. And thank you, because like I said, that water is so important to the well-being of all my people. It's inherent. Thanks.
Kirk Francis, and I'm Tribal Chief at Penobscot Indian Nation.
So can you give us some of your reactions about the arguments you just heard today, impressions about how the case stands now?
So the arguments we heard today obviously are arguments we've been formulating since the beginning of this case. If you look at our second amended complaint, we've been saying the same thing all along. This is about the sustenance-based traditional values of the tribe, cultural identity of the tribe, access to our ancestral territory, and where that right exists. And the state is making the argument that our reservation does not exist within the Penobscot River. So what I heard today was a judge having a real hard time understanding how the state's theory reconciles with protecting indigenous rights when you say that you can just simply stand on an island and cast, and how that's not restricting an ancestral right that I thought he said without saying was basically not your right to do. So I feel really good about today. I think our arguments have been strong all along. They're on the right side of it. I think we have a lot of stature on our side. It helps to have the United States clearly behind us, and all the supporters you saw here today. So I think the judge has a very complex issue to deal with. But I did see the judge really trying to understand why he should rule in the state's favor, and I don't think, from what I saw today, that he'll get to a place where that'll be the case.
And again, as you just said, we heard a lot of emphasis from the state that the tribes could have the right, that they don't want to take away sustenance fishing rights, that the tribes could have the right to stand on the islands and cast a net or cast a line, but didn't recognize the rights of the tribes in the water itself.
Yeah, it's ridiculous. I mean, the judge himself acknowledged there's no fisheries on these islands. So you're saying that basically as far as they can cast, that's their fishery. And, talking about historical references to standing on land, sure, there were no dams. You could walk across the river. You could get to spearing pools. You could do a lot of those things. And to suggest that we were never out in canoes fishing, I mean, I think is a misrepresentation of history, but it's also... Again, I thought the state did a poor job in delineating that for the judge, in saying, the judge asked the question several times, if I rule in your favor, how is their right protected? And I'm not really asking you if you think it's effective today. What I'm asking you is, what gives you the right to have this switch to turn that on and off over a Aboriginal inherent right? So I think the judge asked all the right questions, and I felt really good about where he went with it.
And it seemed, again, we heard from the interveners that they wanted to drag this into the water quality realm, and even the state arguing themselves, they seem to want to be reserving or implying that this case would impact a water quality, when this was the main argument, as we heard, was about jurisdiction over hunting and fishing and clarifications around that.
Yeah, and I mean, one of the sad things really about this case has been the inability to kind of keep everyone focused on what it's about. And, obviously we can't control the other side, but to suggest that interveners, municipal interveners and industry interveners, a majority of whom are not even in the geographical location of this case, have an interest in a sustenance fishing-based case and territorial-based case. Their concern, quite frankly, is that their levels of pollution are going to be affected if a sustenance-based fishing right is accepted, and obviously a water quality standard comes with that from a human health criteria. So I think, I think their arguments also were extremely shallow in a lot of ways. I think they're talking about, a federal court case in Maine versus Johnson that clearly talks about regulation of discharges. You have also, our attorneys basically saying this, we're not saying we can regulate discharges. Matter of fact, we probably concede that we cannot. But
it's not part of this case.
But it's just simply not what we're saying here, and we haven't focused on that. So you heard a lot of things. They tried to bring in parties that own land up and down the river, saying they had an interest in this case, although not one person has come forward in a very highly publicized case. You have the dischargers. Then they're trying to talk about dam owners and all of these other things. And what we're saying is existing uses within the Penobscot River are not the concern of the tribe. The concern of the tribe is protecting a cultural right.
And just quickly, the federal government is an intervener in this case on behalf of the Penobscot Nation. You want to speak quickly about what they bring to this case, what their argument is as far as territorial infringement? Yeah,
so we got two things going on in this case from the federal side. We have the United States intervention, which is an unbelievable precedent-setting lawsuit that they've brought. And I think that the other thing is the congressional amicus brief. So we have an administrative position legally in this case, and also a congressional intent position in this case. And so what you have is the United States saying, we're the trustee, canons of federal Indian law apply in this state, never ceded, never given up, that's it. The tribe, whether you like it, we can sit here and we can talk about unintended consequences, collateral damage. The reality is the right, and that's it. So you heard a much stronger stance from the United States, right? They said, yeah, they own everything, right, in the main stem. But, our position is we don't really care about that right now. Our stress is really around the cultural-based rights of the tribe.
And this is a bigger conversation for another time, but obviously the Maine Settlement Act is something that is being highlighted here, is highly controversial, again, with different interpretations. This case seems to highlight now more than ever a need for, as you've talked before, third-party resolution on issues where there's obviously great divergence.
Yeah, and it's unfortunate that every single case, every single lawsuit that comes up is about the interpretation of the Maine Indian Land Claim Settlement. We have really no third-party dispute resolution process, and we're, as you know, practically begging Congress to get involved in this issue. I think that what you heard today was, again, another very serious bridge or gap between interpretations between the state and the tribe, and that is solely the islands, right? We heard that. Solely the islands means, in everything we saw, the legislative record, the tribal negotiators, everything we've seen tells us that they were saying solely the islands from Indian Island northward. We're not talking about from Indian Island south. We're not talking about way up north. We're not talking about any of those things. Very defined geographical area to deal with the reservation islands. Had nothing to do with saying it's the islands and not the water. Matter of fact, there's a ton of evidence that points to the tribe. The tribe actually submitted a resolution in 1979 in the Maine legislature during the Maine Indian Land Claims through the negotiators, addressing the fact that the river's off the table. This is a land claim. It's not a water rights issue. The river is our ancestral water. That's it. We're not negotiating that. So the state knows that. They have enough atmosphere and language to make the legal arguments, and hopefully the judge isn't going to buy those.
Okay, and finally, what do you expect for a timeline now? The judge is going to be taking this back and making both sides asked for a summary judgment.
We're really not sure. I mean, it could take a month, it could take 6 months, so we're hoping that he takes the time he needs to get it right. And it's a very complex issue, and we suspect that it's going to take a little bit of time, and I'm not confident we'll get anything back before the first of the year, but we'll see.
Anything else you want to add, Chief Francis?
No, we just appreciate everyone being here. I think, as we've talked about before, I think one of the biggest positives of this case is the friendships and interest we've developed all throughout Maine, and we're very proud of that. So, yeah, thank you.
Thanks. Great.